In the last class, we discussed about Bentham's definition of law. Okay, then we looked at different features of law that Bentham defines. Okay, we started with source of law. Okay, we found that the source of law is the expression of will of a sovereign, and that is possible only within a state, and that expression has to take a legislative form. Okay, so you need a superstructure of state. Okay, without that there will be no sovereign, and if there is no sovereign, then there is no law. Okay, so that's the very limited sense of the term with which he uses the word law here. Okay, then we discussed about what a sovereign is. Okay, then we were talking about essentially whether a sovereign is absolute or not, because law is a expression of will of the sovereign. Is this idea of sovereign that Bentham talking about is limited? Because this idea of sovereign seems to be the superior within a state. Okay, what limitations could there be on the power of the sovereign? Okay, so unlike Austin, our philosopher Bentham here says that there could be certain certain rules, okay, certain transcendental rules, okay, which could in fact limit the power of the sovereign. So that could be certain constitutional rules, okay, or certain other religious principles. Those could definitely put as some kind of limitation on what the sovereign can or cannot do. Apart from that, one sovereign may enter into a pact with another sovereign. In such case, from what he calls as pacta regalia, okay, some kind of limitation could definitely be imposed. Okay, but then comes the question of whether sovereign can impose certain limitations on itself. Okay, so on that, Bentham says that it probably does not make much sense to say that sovereign imposes some limitation on itself. It's just like saying that, okay, you make certain resolutions on the New Year's Eve, but then you break them. Okay, so what does that mean? It's simply that you have something called will. Okay, and then you can change your will as well. Okay, if your will is binding on your own self, then it is basically self-negatory. Okay, the idea of will then becomes self-negatory. Okay, so you can say that, okay, one can promise to oneself that I will do this or won't do this, but then there is nothing that says that that prevents that person from making a change in whatever he or she has willed. Okay, so he says that, okay, about self-imposed restriction on the will of the sovereign. But then apart from that, certain other external limitations can definitely be imposed. So he definitely considers constitutional rules to be some kind of limitation on the absolute, so-called absolute power of the sovereign. Okay, now we know that will of the sovereign is the law. So the content of law can be traced from what the sovereign has willed. Okay, now sovereign can, according to Bentham, will in broadly two different ways. One is of that of conception and the other is of adoption. Okay, so as you know, conception means act of conceiving or creating something. So the laws could be a new, okay, fresh creation, okay, through the expression of will of the sovereign. Or in other cases, as you know, it's not possible for the law to for the sovereign to conceive of all possible laws. Okay, it could also adopt laws. Okay, it could also adopt laws which are already in existence or could possibly be in existence in future. Okay, so if sovereign adopts something, okay, a law, that law it becomes law only when it becomes expression of the will of the sovereign. So let's assume that something of that sort already existed. Now you have a new sovereign, okay, and that new sovereign says that, okay, this is something that I accept, okay, that I adopt. Okay, so that is what he calls as susception. Okay, basically adoption of a law that already existed. So once the sovereign adopts it, okay, then you can say that, okay, this is now the expression of the will of the sovereign. Now the problem with this is that, okay, when the adoption is explicitly clear, I mean in the sense that sovereign explicitly says that, okay, I adopt, okay, what already existed, then you can say that, okay, it's in fact a case of imperation on the part of the sovereign, okay, clear case of susception. But when the sovereign does not explicitly say that, I'm adopting an already existing law, then can we really say that it is an expression of the will of the sovereign, or it is a case of imperation? If it is not, but if it is only through a very extended interpretation you say so, then it's merely a case of fiction, it's not a reality. But that's in fact what happens, okay. When a new sovereign comes into existence, he or she does not say that I'm adopting all the laws that existed. But one might assume that if the sovereign does not disapprove of it, then we are to, by fiction, assume that, okay, whatever is not accepted has in fact been accepted. So you can say that in those cases the laws have been adopted, and that can very much be called as the expression of the will of the sovereign. So that's the case of susception. Another case of adoption is known as pre-adoption. Now, whereas susception is basically an adoption of law that already existed, the case of pre-adoption is when you delegate the power of creation of laws in favor of others. Okay, so you essentially say that whatever law is created by that person, I basically accept that. So in such case, a person who is otherwise not allowed to create the law, you by virtue of your own expression of will say that you basically permit that person to create laws, and then you say that whatever laws are created by that person will basically be considered as expression of will of my own. So that also exists, as you know, in modern legal system. The parliament, for example, or for that matter the state legislatures, for them it will not be possible to create a very detailed law that will deal with everything, every fact situation that might arise, okay. Those details are quite often left to certain other officials, okay. So for example, in our case, we have the Act, okay, the National Law University and Judicial Academy, okay. Under that Act, our university has been created, but then we have then, okay, by virtue of the powers which have been given under the Act, okay, the GC has created or adopted, you would say, many rules and regulations, okay. So what about those rules and regulations? Those are not cases of direct expression of will of the sovereign, okay. If you consider those state legislature to be the case, for now, for convenience's sake, to be the sovereign, then you will say that, okay, these are not direct creation of the state legislature, but then you can say that these are cases of pre-adoption, okay. So you would say that, okay, this is a delegated power of legislation given to the statutory bodies, okay, within the university, and when they created the regulation, okay, you can say that they were adopted, okay, so they were pre-adopted by the sovereign, okay. So all these expressions of wills, whether through conception, through the act of conception by the sovereign directly, or through adoption, that is either through susception or pre-adoption, is considered as a case of are considered as the content of law. Okay, so I hope this part is clear to all of you. Is this idea of content of law clear to all of you? You can say yes or no.
Yes, sir.
Okay.
Yes, sir.
So you'll see that positivists are not really that difficult to understand, but they really create lots of problems that you will find later on difficult to understand. So anyway, for now, just keep these ideas in mind. So next important aspect of the idea of law, okay, is the subjects and objects of the law. Okay, so the subject of the law, okay, could be a person, or it could also be a thing, okay. and the object of the law, okay, is basically what the law wants. So object of the law is essentially the imperation, okay, expression of law, will, also known as imperation, by that of the sovereign, okay. So the idea of law that they are talking about, it either creates certain duties, okay, that you shall do or do not do something, or it could confer some liberty on you, in the sense that it is an instruction to others that you do not interfere with them exercising their liberties, okay. Now this idea of law that he's talking about, in his idea of law, the generality of law is not necessary, in the sense that law could also be directed to individuals as much as it could be directed to a specific class of persons or the population generally, okay. But it is not necessary that it has to be always general, okay. So this person, the subject that I'm talking about, okay, it could be an individual, or it could be a class of person, or it could be a thing as well, okay. Subjects, the idea of subjects of law is not restricted to only persons, okay. So the subject of law could either be a person or could be thing bound. But the problem with saying that the subject of law could be a thing bound, okay, does not probably go far enough in analyzing, okay, in the sense that in a world where there is no humans, okay, saying that the subject of law is the thing bound will not convey much, okay. So even when the subject of the law seems to be apparently a thing bound, ultimately it affects humans, okay. So even in those cases, maybe the specific person is not determinate. Ultimately the subject of law is either a person or a class of persons or the persons generally. But Bentham does not say so. Bentham says that subjects of law could either be person or things bound, okay. Now if persons clear, then there is something called object of law, okay. So the law, okay, which is essentially expression of will of the sovereign, intends something to be attained, okay, something to be attained, okay. So that's the act of imperation, okay. That act of imperation wants something to be done or to be avoided, okay. So the object of the law is either an act that you shall do this, that do this, or it's an act of forbearance, that means do not do this, okay. So that's the subject and object of law, okay. Then he says that there is something called extent of law, okay, extent, okay, extent of law, the extent to which the law becomes applicable, okay. Now this idea of extent could either be direct extent or it could be indirect extent, okay. So what does he mean by direct extent, okay. So it's simple that it's the territorial, okay, extent of the application of the law, essentially the portion of the land, okay, that is covered by the law, okay. So that is what he calls as the direct extent of the law, okay. And then he talks about indirect extent, okay. So what is indirect extent? So we are not referring to the territory now or the land covered, but specific circumstances, okay. So the circumstances, okay, fact situations which are within the which are governed by the instant law, that is known as indirect extent, okay. So it's essentially about a relation that an actor has with respect to a particular thing, okay. So if it comes, so that's basically the fact situation or the circumstances, okay. So if the circumstances come within the ambit of the expression of the will of the sovereign, then that is what he calls as indirect extent. Now there is a third thing, okay, which can be considered as a kind of extent, okay, but Bentham does not really say that it's the case of extent. So one might say that, okay, the law is applicable until a certain period of time, okay, the law is applicable for 3 months, 4 months, whatever, okay. So can we say time as a kind of extent? Bentham does not say that duration or time is an extent. Rather, he considers time as something okay, or duration as the thing, okay, within which the law remains effective, okay. So the extent will still be about, the land on a portion of the territory covered, or the circumstances which are covered. Duration is not really extent, but the time within which the law remains effective, okay. And after that the law is not there, okay, you can say something like that. So it's not really extent though for him. So time or duration is not really an extent for Bentham. So that's what extent is extent of law is for Bentham, okay. Now another important aspect of the idea of law that he is talking about are the forms, okay, forms that laws take, okay, aspects or forms that laws take, okay. So he says that laws have two different aspects here of forms, okay. One is the directive, okay, and the other one is sanctional, okay. So essentially what is the difference between these two? The portion of the law that is directive in nature or directive in nature is the portion where the sovereign essentially directly imperates, okay, this is what I want you to do, okay, thou shalt do this, thou shalt not do this, okay, that you shall do this, you shall not do this, okay. So that's what tells you what to do and what not to do, okay. So that's the first aspect of the idea of law that he's talking about. But there is another aspect of law that is very important. It's integral part of the idea of law that Bentham talks about. So you might come across other positivists for whom sanction is not that important, that the idea of law could be talked about even in the absence of sanction. But for these fact positivists, essentially Bentham and Austin, okay, sanction is very important, okay. Now let's look at both of them separately, okay. They are not the same thing, as you know. The law shall, those could be, the directive part could be found in one law, the sanctional part could be found in another law. So within, for example, the penal code, okay, there might be one definition that says what you shall do, what you shall not do, and there could be another provision within the same penal code that says that if you do that, and then this is what the consequence will be, that you will be sent to that you will be imprisoned for a certain duration of time, or you will be fined with certain amount of money, whatever it is, okay. But he says that these two are quite often found separately, but they are integral in nature, okay, in the sense that mere direction, okay, mere direction without the consequence will mean nothing, okay. It will not create any incentive or reason for someone to either obey the command or not obey the command, obey the directive or not obey the directive, okay. So there are two different aspects or forms that the law takes. So the first aspect is directive, okay. So directives, Bentham does not use the word only command, okay. So for example, for just not example, for Austin, it is essentially about command, okay. For Bentham, it is a kind of mandate, okay. So that mandate could take many different forms, okay. So mandates essentially tell you what one is to do, okay. So when it tells you what you are to do, it takes the form of command, that this is what you should do. No, not should, this is what you are to do. Or it could also take the form of prohibition, okay. Prohibition is nothing but a form of negative command, okay. It essentially tells you what you are not to do, okay. And then there is a third kind known as permission, okay. So permission again, okay, it could either allow you to do something that you are otherwise prohibited from doing, okay, or it could give you permission to not do something that you are otherwise to do, otherwise you are to do under a particular command, okay. So these are the forms that it takes, okay. So it could be a command, it could be a prohibition, it could be a non-command, or it could be a non-prohibition, okay. So it's quite clear, okay. Now these command, prohibition, and then a non-command, non-prohibition are also related to one another in a certain way, in the sense that it could be compatible, or it could be incompatible with the other. So for example, it is quite clear that a law will be problematic if it tells you that you shall not do this in a certain fact situation, and at the same time it says that you shall not do something within the same fact situation. So you see that if there is incompatibility, okay, then there is problem. Okay, so a law cannot at the same time command you to do something and also at the same time prohibit you from doing something. Okay, so there are certain relations that you will see between command, prohibition, permission, non-command and non-prohibition, which are essentially permissions. Okay, now the difference between the first kind, that is command and prohibition on the one hand and permission on the other, is that permissions are non-coercive. Okay, they do not coerce you. When you are permitted to do something, they do not compel or coerce you into doing or not doing something. They create liberties in your favor. Okay, they create liberties in your favor, or it gives you a choice to either do something or not to do something. Then the question that obviously arises is, are these cases of imperation? Okay, so this is where you see the difference between Austin and Bentham. Okay, so in Bentham's definition, this is as much part of the idea of mandates that he's talking about. But then who is the law then directed to? Okay, obviously it gives you the liberty, so it is directed towards you. But when you are given a liberty, it is also directed to certain others. Okay, some others. Okay, who would, in the absence of this liberty, be justified to interfere, but in the light of the liberty, not justified to interfere. So for example, when it comes to driving a vehicle, okay, if you do not have the license, so you do not have the liberty to drive a car. Okay, but if the sovereign gives you the liberty, license to drive a car, you now have a choice to either drive the car or not drive a car. So when you are given a license, it does not mean that you have to always be driving a car. No. So it gives you a choice. Okay, but it also directs. So for example, from the traffic police from interfering with you, okay, with your liberty to direct, okay, without a justified cause. Okay, so yes, there is direction even in such cases, but probably not directly directed to you, but to others who would, in the absence of the liberty given to you, be justified in interfering. Okay, so yes, that's what what do you call it, directive part of the form or aspect of law. Okay, so yes, so that's the first part, okay, of the law. But as I told you, there is another part of the law which is as much important. Okay, without that, law does not really have any meaning. Okay, so that part is the sanction or incitative part. Okay, incitative aspect. Okay, that's what gives force to the law. Okay, so it need not be explicit. Okay, it need not be explicit. It could also be implicit. Okay, but it creates a motivation in you for obedience. So that's why we call them fact positivists, in the sense that they are not reliant on this idea of of a norm that says that you ought to follow the law. So even when you escape the grip of law, the law still is there because you ought to follow the law. But for these fact positivist thinkers, it seems that law exists only when the sanction is in fact effective. Okay, if it is not effective, it seems that there is not a case of law. Now that's why the sanction or sanctional or incitative part of law is very important for them, and it is very integral part of the definition of law that Bentham gives. Okay, this is what creates motivation for you to obey the law. Okay, that motivation could either come from some punishment or it could come from some reward. Okay, now there is some problem with this though. Okay, So for example, when the motivation is from punishment, okay, it seems that I do not have a choice. Okay, if I do something that I'm not allowed to do, okay, then punishment follows. Or if I do not do something that I'm supposed to do, then punishment follows. It's simple, isn't it? It's motivation enough for me to do something. It goes well with the idea of imperation that we see in the first aspect of the law. But what about the case of reward? Okay, when the motivation comes from reward, it seems to be the case that you are left with a choice, that if you do something, then you will be rewarded with something. Okay, but you might as well not do it and not claim the reward. Okay, can we say that it is a case of imperation? Not really, but then Bentham includes both punishment as and reward as a motivation for for following the law. Okay, so for Bentham, as I said, I reiterate it again, that punishment is an intrinsic aspect of the idea of law. Okay, so the question that remains is my obedience to the law. Okay, does it come from the first aspect of the law or from the second aspect of the law? So does it, my obedience to the law, does it come from the expression of the will, okay, or does it come from the fear of consequence? Okay, that's the question, which it seems in case of Bentham comes only from the consequences, okay, not from really the first aspect. Okay, then the problem then arises is that what is the value of imperation then? Okay, so anyway, that's the problem which remains, but that will be explained by other philosophers that we will take up later on. Okay, so anyway, if you focus on the first aspects, let's say that the act of obedience come from the imperation, then if you focus only on the imperative part, then there is some kind of ought there, that you ought to follow the expressed will of the sovereign. However, if you are talking about obedience in terms of the consequences, then you are merely giving me a description of the cases in which there is law and of other cases in which one has successfully escaped the grip of the law, to be cases in which there is no law. Okay, so this is the problem that positivists struggle with. Okay, so we will see the problem described in and explained in more details when we take up H.L.A. Hart's attempt at defining the law. Okay, so that's essentially the idea of law that they are talking about. Okay, so here's a problem that arises though with respect to this question of obligation. Okay, something that was later on taken up by later on emphasized on by legal realists. Okay, so that is the question of obligation. Okay, the question of obligation. So if you are a fact positivist, okay, the idea of obligation probably does not really make much sense. Okay, make much sense. Okay, why is that? So as I told you, it seems to be the case that law is there when the law has been successfully implemented, in the sense that something has been commanded and someone who is trying to escape the grip of it has been subjected to consequences. But there are many other situations in which people can successfully escape from the consequences of not obeying the will the imperation of the law or expression of the will of the sovereign. Okay, what about those situations? Can we say that there is something called law, okay, there? Now you know that the question of obligation does not really arise here, because the moment I want to talk about obligation, the question is essentially to be put in terms of whether I ought to follow the law. But that does not even arise in the case of fact positivism, because you merely describe, okay, you merely describe a fact situation. If you're describing a fact situation, there is no question of ought there, okay, whether moral or non-moral or amoral ought. Now that's where the problem is. Okay, that's where you see some kind of foresight in the works done by Bentham that you do not see in the works of Austin. Okay, so Bentham says in this situation, okay, that whether there is an obligation to obey the law, okay, will depend on certain other factors. Okay, So what are those? Okay, so those will be basically, that's it. Think about it. Okay, so a law says that you shall not do something. Okay, if you do this, then this will be the consequence. Okay, but then that is not sufficient. Okay, you need other remedial laws. Okay, remedial appendages. Okay, or subsidiary laws. Okay, so those subsidiary laws will be addressed to officials. Okay, so for example, to judges. Okay, that you shall punish a person only after adjudicating the matter in a certain way, only after finding the person to be guilty, okay, of a certain conduct. Okay, or it could also be addressed to, for example, police or other law enforcement agencies. Okay, so these are subsidiary laws, okay, which also have to function, okay, so as to prevent a certain evil. Okay, now the problem here is that the more the laws that you have here, the more there has to be an expectation on your part that those laws will effectively be followed. Okay, and there is also a likelihood that those laws are not followed. Okay, so if you look at this entire picture that we have drawn, okay, from the perspective of the sovereign, okay, whether the law will ultimately be followed or not will merely be a case of prediction based on something called probabilities. Okay, you as a sovereign will say that, okay, how likely is it that this imperation that I'm doing will in effect be realized. Okay, and that realization is possible only when the subsidiary laws are also followed. Okay, so when you have these many laws which are scattered here and there, and all have to be followed, and only then you can say that legal obligation has in fact been created. So that means that you cannot for certain say that, okay, this is what is going to happen. You always have to predict that this is what is likely to happen. Okay, so that is something which was foreseen by Bentham, but he did not go far. Okay, now this is something that was later on taken up by legal realists, okay, who just exaggerated this thing and then said that, well, what is the law? Okay, and then they say that law is in fact what the judges actually do. Law is not what you find in the rule books. Rule books are nothing but those are expressions of the sovereign's will. But that's not what actually happens in the legal system. So what actually happens? What actually happens is an empirical reality. That's something that you have to observe. So where do you observe it? You observe it in the court of law. That you do not find the law in the written letters, but you find the law in the way that the courts have interpreted. So if you were to know what the law is, you have to think in terms of a bad person, a bad man. Okay, a bad man will always try to find out the loopholes of the law. That bad man will essentially try to find out that how is it possible for me to do something and then also escape the grip of law. Okay, so they essentially take it to extremes and then say that only the bad person will be able to tell what the law is and what the legal obligations are. Okay, now obviously this is an exaggeration which has been done by the legal realists. Okay, but then you see that Bentham was such a keen thinker, such a foresightful thinker, that in his idea, or in his description of law, he could say that law ultimately, or legal obligation ultimately, is a case of prediction based on probabilities. Whether you like it or not is different, but you have to accept that this is in fact the case. Okay, but then we do not have to accept that this is the definition of legal obligation. Okay, we do not have to, because we have other competing ideas which are there. So we will look at them later on. Okay, so I hope the idea of legal obligation, as Bentham talks about here, is understandable to you. Is there any confusion that you have from the explanation that I tried to provide to you guys? Is it understandable? Okay, anyone else who has any confusion here? Okay, so that means it's quite simple. So anyway, so that's essentially what the idea of law is. Okay. Now, as you know, Bentham is a person, okay, who why was he doing this entire analysis? Okay, his entire analysis was essentially a critique that he had developed as against common law. Okay, common law which had problem of being unclear. Okay. Uh, so he wanted to tell you about how to make laws. Okay, how to make laws. Okay, so before you make laws, you need to know what those different aspects of laws are. Okay, so that's why he's giving you this very elaborate definition of law. Okay, now one important aspect of this definition of law that he's talking about is how the sovereign's will is expressed. Okay, he says that the sovereign's will should be, when it is turned into a legislation, should be completely expressed. So expression of the will of sovereign has to be complete. Okay, if the expression of will of sovereign is complete, then the judges have little room to go beyond the legislation itself. But if it is incomplete, then judges will take that opportunity up to give some kind, to create the law on behalf of the sovereign. So that is not a happy conclusion for Bentham. So he says that the expression of the will of the sovereign should be complete. Okay. So when it is complete, the judges apply literal interpretation. When it is incomplete, the judges apply liberal interpretation. Okay, so he's telling you that there is something called individuality of law. Okay, that each law is separate from other. Okay, there is something called individuality of law, and when the legislation is enacted, a good legislator will ensure individuality of law. Okay, now what does individuality of law mean? Okay, so there are two different aspects of individuality of law. Okay, so an individual law is essentially a complete law. That's what he is talking about, that law should be complete in expression. Okay, so he's saying that an individual law is a complete law. Okay, so what is an individual law? Okay, so individual law will have two different qualities, that it is integral and that it is one unit. So there are two aspects. Okay, one is integrality of law, the other one is unity of law. What does that mean? It essentially means that it should not contain more or less than the whole law. So he has an idea of what is known as whole law, and expression of that should not go beyond or less than the idea of whole law. Okay, now what is a whole law? A whole law has integrality as well as unity. So what is integrality? So he says that there are three different aspects of integrality. Okay, law is integral whole. Okay, when it is complete in expression. Okay, so the expression of the law is complete. Okay, and that it is complete in connection. What does that mean? That laws are, you do not find a law within one provision of a particular code. Okay, you find a law scattered in different parts or different legislations as well. Okay, but the legislator has to make the necessary connections. Okay, and then the third aspect is the design. Okay, it has to be complete in design. So in the sense that laws are quite often created to address certain mischief. Okay, a properly designed law, okay, will be addressing the mischief is in entirety, whereas an improperly or incompletely designed a law will not address the mischief completely. So when the mischief is not completely addressed, that's where the judges are compelled to go for deviate from the this literal rule of interpretation. Okay, so when the design is incomplete in amplitude, okay, then what do? Then they have to go beyond the literal edges. Okay, but if it is incomplete in discrimination, then they have to create exceptions to the general expression of will. Okay, so that will be what we know as strict interpretation. Okay, So this is the first part, okay, known as the integrality of the law. And then the second aspect is unity of law. Now, what is unity of law? He says that unity of law is nothing but the specific fact situations to which a law is directed, okay. So yes, each act situation will create separate, will be the object of separate law. So when he says that, he does not say that same act situation will not be subject to different law. No, that is not the case, okay. So for example, you know that same act could lead to tort as well as crime. Yes, come in. So but then what he is essentially saying is that each act situation will create one particular kind of law, okay. So yes, but that does not mean that one act situation will only lead to one offense. He's not saying that, okay. But that's essentially what the idea of unity of law is. Now, if a law possesses both this character of being integral as well as one unit, okay, then you have something called individuality of law. So I think I'm past my the limited time that I have for today, so I have to end it here.